Okay, this is my first case brief here. And for this case brief, we are going to talk about Burger King versus Rudzewicz. So what happened was is John Rudzewicz, who was accountant in Michigan, was approached by Brian McShare, who was the son of one of his business partners, to do a Burger King. So Rudzewicz was the money, and McShare was actually going to do the day-to-day operations and management. So they started negotiating with Birmingham, Michigan District Office of Burger King, and McShare actually went down to Miami for the training course. And eventually, in June of 1979, they signed the final agreements and commenced operation. Okay, it caused Rudzewicz to make himself personally, he had to personally guarantee. So he became personally liable for over $1 million in payments over the 20-year franchise relationship that was supposed to go from 1979 to 1999. So Rudzewicz fell behind on the royalty payments. He couldn't meet his contractual obligations, but he kept operating the Burger King, which is a problem because it's trademark infringement, because Burger King had terminated the franchise relationship, and also he was using all of Burger King's proprietary information to keep going. So Burger King sued Rudzewicz. They brought a diversity lawsuit in the U.S. District Court and the Southern District Court of Florida, and they alleged that there was trademark infringement and a breach of contract. So what happened is Burger King, they won there in the district court, and it was appealed to the Court of Appeals where they lost. And so ultimately this ended up in the U.S. Supreme Court, where the U.S. Supreme Court, well, let's just keep going before I explain. So the issue is whether the exercise of the long-arm jurisdiction offended traditional conceptions of fair play and substantial justice embodied in the Due Process Clause of the 14th Amendment, and also when can a contractual relationship give rise to personal jurisdiction in a distant form. So these really are the issues, right? Could the long-arm statute make Rudzewicz party to a lawsuit in the state of Florida? And then if you sign a contract with a company in a distant foreign state, can that also make you subject to a court case there? So the rule that really was at the heart of this case was this Florida statute in section 48193(1)G. It says any person, whether or not a citizen or resident of the state, who personally or through an agent does any of the acts enumerated in this subsection, thereby submits himself or herself, and if he or she is the natural person, his or her personal representative, to the jurisdiction of the courts in this state for any cause of action arising from the doing of any of the following acts, and it is breaching a contract in section G in the state by failing to perform acts required to the contract to be performed in the state. This is exactly what Rudzewicz did. He signed a contract with a company in the state of Florida, and it was governed by Florida law. In the contract, it said that, and he stopped paying the bills. And in addition to that, he continued to operate after termination. So it was also trademark infringement. So what is the analysis? Okay, so first of all, it was established that Rudzewicz had minimum contacts with the foreign states, not only by signing the contract, but previously negotiating with the corporate office in Miami to get to a fully executed agreement. This is evidence that Rudzewicz and McShare had acknowledged the Birmingham District Office was more of an operational or supervisory position, but they didn't have the authority to resolve contractual disputes. The next thing to consider with this is that, okay, so you do have minimum contacts, but you have to look at other factors to determine whether the assertion of personal jurisdiction would comport with fair play and substantial justice. So is it still fair, and is it substantial justice for us to assert this PJ or personal jurisdiction? And International v. Washington shows that courts may evaluate the burden on the defendant and the foreign state's interest in adjudicating the dispute and the plaintiff's interest in convenient and effective relief, and also interstate judicial systems' interest in obtaining the most efficient resolution to controversies and shared interests of several states, such as in Worldwide Volkswagen v. Woodson. We know that Worldwide Volkswagen v. Woodson, it really had to do with the highway system. And so this is important for states to understand how are cases that are going to happen on this interconnected or interstate highway system going to be resolved. So Rudzewicz needed to prove that the presence of some other consideration would render, let's fix this, render jurisdiction unreasonable, and in most cases that means unconstitutional. So here's the big point. Minimum requirement of fair play and substantial justice may defeat the reasonableness of jurisdiction, even if the defendant had purposefully engaged in activities in the foreign state. So even if Rudzewicz had purposefully engaged in activities in the state of Florida, there's a minimum requirement for fair play and substantial justice. So fair play and substantial justice could say, yeah, you purposefully engaged in activities in this state, but it would be against the due process clause, against that, it would be against that, what is it called? The due process clause of the 14th Amendment in order for you to be brought into court in here. So what's the conclusion? The Supreme Court of the United States overturned the Court of the Appeals decision, and they said that the district court in Florida was correct, and that Senator Rudzewicz in Florida was not unconstitutional and did not violate fair play and substantial justice. The Supreme Court did not agree with the Court of Appeals assertion that the parties' dealings involved a characteristic disparity of bargaining power and elements of surprise, and that Rudzewicz and they didn't believe that Rudzewicz lacked fair notice. The Supreme Court agreed with the district court that the defendants were experienced and sophisticated businessmen. They did not act under economic duress or disadvantage imposed by Burger King. Rudzewicz was represented by counsel through the entire complex transaction, and he himself was an experienced accountant who for 5 months conducted negotiations with Burger King and personally obligated himself to pay more than $1 million in payments. It says that he was able to secure a modest rent reduction and concessions from the Miami headquarters. He paid rent and fees to the Miami headquarters, and also the contract had a provision in it that said the contract was entered into in the state of Florida shall be governed and construed under and in accordance with the law of the state of Florida. This choice of law designation does not require that lawsuits concerning the agreement be filed in Florida. This law does not create personal jurisdiction, but with everything else, it's reasonably foreseeable that a dispute could arise and case could be filed in Florida. The fact that provision said that it is not a requirement for all suits to be filed in Florida gives rise to the possibility and acknowledgement that a case can be filed in the state of Florida. Okay, so that's the conclusion of the IRAC method. So we have the facts, we have the issue, we have the rules, we have the analysis, and we have the conclusion. Now let's take a look at the dissent. So Justice Stevens with Justice White, he dissented. He said there were significant elements of unfairness requiring a franchisee to defend a franchise in a form that was chosen by the franchisor. And the franchisee had no place of business, no employees in the state, and was not licensed to do business there, and all the principal contacts were with the Burger King, Michigan office. All right, the other thing is, then Justice Vance of the Court of Appeals for the 11th Circuit said he would affirm the judgment of the Court of Appeals because Rudzewicz's home state is where he conducted all the negotiations and wholly supervised the contract, and had reason to believe that the supervisory office would be the same state that BK or Burger King would file suit. He also said that he was financially unprepared for a suit in Florida. The franchisees are a local business. The franchisor has a dominant role. The franchisees signed a standard form contract, and even though they say, yeah, he was able to negotiate a modest rent concession, he's saying that the written contract had higher minimum monthly rent computed on a base that was in excess of what was discussed in those oral negotiations, and Burger King resisted price concessions, and they sued, and then so he had less money, okay, and then they turned around, and to add insult to injury, they sued Rudzewicz far from home, which also impeded the ability to call Michigan witnesses who were important to his defense. So there we have it. My first case brief, Burger King v. Rudzewicz case brief, win, lose, win. Burger King was the winner. Thank you so much for tuning in to today's episode of Legally Ravenhair, Legally Not Right.